Thank you, Sonal. A very good morning to all of you, and welcome to this webinar. Today we will be discussing on how to run a factory while being fully compliant. So as you all know, there's a whole gamut of laws and regulations that we need to adhere to in the Indian context in order to ensure that factories are fully compliant with the various regulations. So we need to understand that the multitude of laws and regulations that cover the Indian space are really vast. It's a really vast landscape, and so it would be difficult to cover all the laws and regulations in minute detail in a session as short as this. So my endeavor would be to, more than anything else, to enkindle your curiosity so that you would go deeper into the concerned legislation covering your industry, and try to understand the concerned legislations covering your industry more deeply, so that you get a better hold of how these legislations will actually apply to your industry. So this is this in the context of the vast landscape of rules and regulations that we have in India would be a small precursor to the to the fact that law as such is a very vast subject, and it is difficult for a person who is explaining the various aspects of law to be able to cover the whole aspects, the various aspects of law in such a short span. So to ensure that that all the laws are covered, what I would basically do is to take you through the important aspects, the important compliances of the various laws, the important compliance aspects of various laws, and introduce you to them, move on from one law to the other, because I think given the short time that we have, this would be the best way for us to be able to cover all the laws during this short period. So what I would also request you to do is please make notes of the presentation that is being made, and please make notes of your questions, and please send your questions to me immediately after the session is over. You can send it to the coordinator who will direct the questions to me. You can also send me questions on my email, which will be directed to my email by the coordinator. So with this, I'd like to take you through the various important enactments and the various aspects. So as we know, here we're dealing with hardcore legislations, we're dealing with hardcore compliances. So to that extent, we need to understand that these are not guidelines, and failure to failure to adhere to these compliances will result in penal consequences. So these penal consequences could be imprisonment or fine or both. So we need to keep this in mind when we look at the requirements of the various laws that we're going to discuss in this presentation. Okay, so as I already said, the setting up and running of a manufacturing unit in India attracts the requirement of having to obtain licenses, approvals, registrations from the various departments, central and the. So if you are setting up a factory in a particular state, we need to understand that we will not only be looking at compliances in that particular state, but also we'll be looking at compliances, central compliances, which govern the operations of the factory in that particular state. So what we have also sought to do is to separate the compliances into three aspects. One is prior to the construction of the factory. The second one would be post-construction but pre-production. That is after the construction of your factory, you haven't started producing the goods in the factory, so this would be during that period. And the third stage would be the post-production stage. So prior to the construction of the factory, what are the compliances that you need to adhere to and ensure that you have it? You need to ensure that you comply with the requirements of the IDRA Act, the Industrial Development and Regulation Act. You need to file Form IEM with the Department of Industrial Policy and Promotion. So that will be the compliance under the IDRA. Under the Factories Act, you need to apply the prescribed form before the Chief Inspector of Factories for getting written approval in respect to the site on which the factory has to be constructed. Now, I will not be going into details on what the form will need to, how the form will need to be filled and what needs to accompany the form, because for the purposes of convenience and ease of reading, I have put that in the presentation itself. And since I hope the presentation has been sent to all of you, you'll be able to go through the requirements, the more minute details of the form and the various documents that need to be attached to the form and filed with the Chief Inspector. And then, you know, if you still have any doubts, if you need any clarifications, you can always, as I said, write to me or take that clarification during the interactive session. Under the Boilers Act, there's a compliance. You need to ensure that prior to the erection of the boiler, you need to ensure that it has been inspected by the inspecting authority and the certificate has been issued. And this certificate is issued in Form 2B. You have a compliance under the Water Prevention Control and Pollution Act, where you need to obtain an NOC for the State Pollution Control Board prior to establishment of the factory. You also have a compliance under the Air Prevention and Control of Pollution Act, where again you need to obtain an NOC from the State Pollution Control Board prior to the establishment of the factory. You may note that the penalties for non-compliance appear to be pretty rigorous. We've also mentioned the penalties for non-compliance in the fourth column of the slides, just to instill a sense of seriousness into how important these compliances are. So you would see that if you don't obtain NOC from the State Pollution Control Board under both the Water Prevention and Control of Pollution Act and the Air Prevention and Control of Pollution Act, there could be imprisonment for a term of not less than 1 year and 6 months, which may extend to 6 years with fine. So you need to ensure that these things are taken care of. There is also a provision for continued contravention of ₹5,000 for each additional day. If the contravention continues beyond 1 year after the date of first conviction, then the offender may be in prison up to 2 years, which may extend to 7 years with fine. So, as you see, flouting these compliances is not going to be easy, and one is to bear the consequences, some of which could be pretty serious. You have a compliance under the Employee State Insurance Act, where you need to ensure that you are registered with the authority under the ESI Act. You need to ensure this if you're employing more than 10 employees in a specific location, in a specific factory location. You need to furnish declaration of registration in Form 1 to the concerned regional sub-regional office within 15 days after the Act becomes applicable. So that is after you employ 10 or more people, you need to furnish this declaration. There's another requirement as well, which has been mentioned, in the same line. Let's go on to the next enactment. Under the Employees Provident Fund and Miscellaneous Provision Act, you need to obtain registration if you have 20 or more employees in the factory. You have the Contract Labor Regulation and Abolition Act. Here also you need to obtain registration if you have 20 or more contract laborers. So this application will have to be made the prescribed form and after payment of the required fees. Application has also to be made for employing contract laborers who have not more than 15 days in the prescribed format. That is, if you're going to employ temporary contract labor, and if you're not going to have them for more than 15 days, you still have to apply to the registering authority. Now, you need to understand that there are some of these laws which have been enacted by Parliament and which are enforced by the central government. There are some of these laws which are enacted by Parliament but which are enforced by both the central and the state governments. And some of these laws which are enacted by the Parliament but enforced purely by the state government. So the Contract Labor Regulation and Abolition Act is one of those acts which are regulated by both the central and the state governments. And the question on whether the central rules would apply or the state rules would apply would depend on the kind of operations, would depend on the kind of industry that the factory is under. For example, if the factory is producing telecom apparatus and is under the telecom industry, then it is not the state rules that will apply, but the central rules. So why would the central rules apply? This is because under the Contract Labor Regulation and Abolition Act says that the appropriate government would be the central government if it is the central government, if the establishment is controlled by the central government as mentioned under the IDRA Act. The appropriate government would be the state government in respect of any other establishment. So in order to see if the establishment is controlled by the central government, you need to look at the IDRA Act, that is the Industrial Disputes Regulation Act. In the Industrial Disputes Act, you need to look at the Industrial Disputes Act. So if you look at the Industrial Disputes Act, the Industrial Disputes Act states that the appropriate government would be the central government in respect of any controlled industry. Now, the Industrial Disputes Act does not mention what a controlled industry is. It just says a controlled industry as may be specified under the Act. So, a controlled industry has been specified by virtue of a notification issued in July 2004 by the Ministry of Labour and Employment, which basically states that a controlled industry includes an industry which is in the business of telegraphy. So I can read out the provision to you. It says, in pursuance of the relevant provisions of the ID Act, the central government hereby specifies for the purpose of this subclause that the controlled industry engaged in the telegraph services which is controlled by the central government. A controlled industry engaged the telegraph services which is controlled by the central government under Section 4 of the Indian Telegraph Act. So if it is an industry which is engaged in telegraph services and which is controlled by the central government under Section 4 of the Indian Telegraph Act, then it would be a controlled industry. So by virtue of that, an industry which is controlled by the government, that is, if the government is issuing licenses for running that particular industry, it is constituted as control. So the telegraph, so an industry which is involved in telegraphy service is basically a controlled industry, and hence such industry is and hence such industry is construed to be an industry which is which will be governed by the rules of the central government. So here we have a situation where the industry, by virtue of being in the telecom industry, is not run by, it's not governed by the state laws, that is the laws in which the particular factory is situated, but is governed by the central laws, that is the central rules under the Contract Labor Regulation and Abolition Act. So there could be situations like this where it might look as if a particular industry is governed by a particular state rule, but that might not always be the case, and one has to do a further research to be able to be sure that the industry is governed by a state rule or a particular central rule. So, as I said, just to give you some examples, laws enacted and enforced by the central government would be laws like the Employees State Insurance Act, the Employees Provident Fund Act, the Mines Act, etc., etc. The laws enacted by the central government and enforced by both the central and as well as the state government. One example I gave you was the Contract Labor Regulation and Abolition Act, which we are looking at right now. The Child Labor Prohibition and Regulation Act, the Equal Remuneration Act, the ID Act. So these are laws which are governed by both the central, enacted by the central, but governed by both the central and the state governments. So you need to read the fine print a lot more closely to be able to ensure that a particular law is actually governed not by a state rule but by a central rule, and vice versa. You also have labor laws which are enacted by the central government but enforced by the state governments. Like the Factories Act, it is enacted by the central government but enforced by the state governments. The Plantation Labor Act, the Trade Unions Act, the Weekly Holidays Act, the Employment Exchange Compulsory Notification of Vacancies Act. These are some of the laws which are actually enacted by the central government but enforced by the state governments. So let's go on. We now come to the Interstate Migrant Workmen Regulation of Employment and Conditions of Services Act. So here you need to apply the prescribed form to the registering officer with applicable fees for the registration of the establishment along with the registry receipt. So you need to note here that this applies if an establishment employs 5 or more interstate migrant workmen. Interstate migrant workmen can be employed while registration of the registration of the establishment is pending with the registering officer if the application for registration is filed within due time. So if you already filed the registration and if it has been timely filed, you can still go ahead and employ your migrant workmen. Let's go on to the next law, the Payment of Gratuity Act. The Payment of Gratuity Act, you need to file a prescribed form with the controlling authority within 30 days of the opening of your factory. So there is no threshold here under the Payment of Gratuity Act, if you've noticed. The moment you open your factory, you need to file your the prescribed form. You have certain compliances under the lifts and escalators acts and rules. In case you're going to have lifts and escalators in your factory, you need to ensure that you apply the prescribed format to the electrical inspectorate for erecting and installing a lift or an escalator. So what you need to do, the details of it is all mentioned in the slide, so I'm not dwelling on it. It's there for your easy reference. Going to the next law. Prior to the construction of the factory, you need to ensure that you have the required permissions from the panchayat, the municipality or the municipality corporation, which has jurisdiction over the area where you are planning to set up your factory. So that is one compliance you need to take care of. This compliance is the requirements of this compliance could vary from place to place. So this is something you need to check with the local authorities and ensure that you are in compliance with them. The next law would be the Indian Wireless and Telegraphy Act, that with the Indian Wireless Telegraphy rules. This compliance applies only if you intend to use walkie-talkies in your factory. So if you intend to use walkie-talkies in your factory, you need to apply for a network license from the Telegraph Authority for possession of the wireless telegraphy apparatus. You need to file out the required form. You need to ensure that you are a citizen of India, you are above 18 years of age, and you hold a certificate of proficiency and license of the class established to maintain and work wireless telegraphy apparatus. To the next law. This is the Explosives Act read with gas cylinder rules. So you need to, if you're going to have any compressed gas in your premises, if you're storing any compressed gas, as a person who's running a factory, there could be a lot of implements, a lot of tools in the factory, which could, in one form or the other, be hazardous to personal safety. So there are various legislations which take care, which ensure that you have to follow certain guidelines to ensure that these equipments that you have to run the factory meet the basic standards of safety required, so that the people who are working in the factory are protected. So we'll be looking at some of the legislations as we're going forward. One of these is the Explosives Act read with the Gas Cylinder Rules 2004. So you need to ensure that you submit the following to the Chief Controller for obtaining prior approval with regard to the premises for storing compressed gas. So the various details on how this application should be made is mentioned in the row. I'm not dwelling on it, and it's available for your reference. You have certain compliances under the Petroleum Act 1934 read with the Petroleum Rules 2002. This is if you're storing petroleum, you need to ensure that you store petroleum in the manner that is specified here. You have different classes of storage containers which you can use, and each of these storage containers have a certain parameter which needs to be added to, and you also have different classes of petroleum, and the compliances for the different classes of petroleum mentioned here. So I'm not dwelling on this since it has been mentioned here, and if you need any clarifications, we can take it up later. You have certain compliances under the Electricity Act that the Central Electricity Authority, measures relating to safety electric supply regulations. This compliance is applicable if you install a diesel generator set. This compliance requires that you obtain from the State Electricity Board a copy of the sanction. The power allocation sanction should be obtained from the State Electricity Board, and a copy of the same should be forwarded to the Chief Electrical Inspector. You also need to ensure that you install switchboards and distribution boards wherever necessary in accordance with the law. You also need to ensure that you meet other compliance requirements like installation of fuses, earthing of the installation, etc. in compliance with the law. We have the Explosives Act 1884 with the Static and Mobile Pressure Vessels Unfired Rules 1981, which need to be adhered to. Now, the Explosives Act mentions that you obtain a certificate of safety signed by a competent person, and this has to be furnished to the licensing authority prior to using any vessel for storing any compressed gas. So if you're going to store any compressed gas in your premises, then you need to ensure that you're in compliance with the various laws, various points that I mentioned here, the various provisions of this law that I mentioned here. You need to ensure that the pressure vessel is of a certain dimension and is able to store the gas in the manner that has been mentioned here. You need to apply to the chief controller for getting an approval before storing any compressed gas by submitting certain details. Those details are also mentioned in the slide. You need to apply to the district authority for obtaining a no objection certificate for storing compressed gas and pressure vessels in the proposed premises. And prior to applying for a storage license from the chief controller, you need to send 2 copies of the site plan showing the location of the premises proposed to be licensed. So you need to apply to the district authority before applying to the chief controller. We go on to the next enactment. This is the Hazardous Waste Management Handling and Transboundary Movement Rules. So this compliance applies if you import or export hazardous waste for recycling, recovery, and reusing. So you make an application to the State Pollution Control Board in Form 1 to get an authorization for generating, processing, treatment, and for whatever other reason you are using the hazardous waste. And you also need to ensure that if you are recycling the hazardous waste, you need to make an application to seek consent for the same. So you have 2 different forms that you need to apply, you need to fill up. So one is to make an application for generating, processing, treatment, package, storing, transportation, etc. The other one is for recycling. The process for that is mentioned in the slide. And you also need to ensure that you apply with the consent that you received under the State Pollution Control Board under the Prevention of Water Pollution and the Prevention of Air Pollution Acts that we just discussed. You need to ensure that if you're transporting hazardous waste to another state for treatment, you obtain a no objection certificate from the State Pollution Control Board of both the states and also the state through which the particular hazardous waste is being transported. But in this case, the transit state you don't require to get an NOC from the transit state, but you need to intimate the Concerned Pollution Control Board of that transit state that you are transporting hazardous waste. Going on to the next enactment. The Ozone Depleting Substances Regulation and Control Rules. This compliance applies if you're using or processing ozone depleting substances. For example, if you're a refrigerator manufacturing industry and you're using the substance freon, which is supposed to deplete the ozone in the atmosphere, these are the compliances that you need to adhere to. So the details of it are mentioned in this slide. I will not be going into the details because it's available, and if you need any clarifications, we can take it up later. biomedical waste management and handling rules. This law basically applies in case your factory is using biomedical waste that's generated in your premises. So you need to apply in the prescribed form for grant of authorization for the purposes of dealing with biomedical waste. What is biomedical waste? This means any waste which is generated during the diagnosis, treatment, or immunization of human beings or animals, or in research activities pertaining thereto, or in the production or testing of biologicals, and including categories mentioned in Schedule 1 to the enactment. So this would basically apply to laboratories, to pathology labs, and such other establishments which deal with biomedical waste. Going on to the next law, Fire Services and Fire Safety Act and rules. These are state specific. You need to ensure that you obtain a no objection certificate from the Fire and Rescue Services. Along with the application for obtaining an NOC, submit the following. Firefighting arrangements should be made as per the relevant rules and approved firefighting system plan. Fire escape and main staircases should reach up to the rooftop. Fire lift is essential in all blocks as per the National Building Code. So there is another code which has almost achieved legal, legal sanctity by virtue of the fact that this has been referred to under the Fire Services and Fire Safety Act and rules. The National Building Code has been referred to under the Fire Safety Act and rules, and hence needs to be adhered to as much as you'd adhere to any law. You have the Environment Protection Act 1986 led with the Environment Impact Notification. So this you will need if you are carrying out any project which has been listed out in Category A and Category B. So what those projects are and how they are classified is all mentioned in the slide. If you have any questions on that, we can take it up later. This is not a particular law that we're looking at, but we're looking at this whole system of single window clearances that is available in some of the states. You don't have to approach different authorities, multiple authorities for seeking sanctions and approvals in order to set up your factory. If you're setting up your factory in some particular states, so you go to a single authority who acts as a single window, and this authority will be able to obtain the required consents, required permissions from the other authorities and give them to you. So you have this single window system in some states like Gujarat, Tamil Nadu, Punjab, Rajasthan. A lot of other states are working on this single window clearance system, and I'm sure we're going to have many of this in the near future. But for now, the states are stated in the slide. Going on to the next enactment. The Factories Act. Now this is post-construction but pre-production. So we are coming to a situation where the construction is over, but the production is not started. So there are certain compliances that you need to ensure at this stage as well. You need to ensure that you furnish certificate of stability in the prescribed form issued by a competent manager in respect of every engineering construction. So if there is any engineering construction, it could be 1, it could be 10. In respect of each of them, you need to furnish a certificate of stability to the Chief Inspector of Factories and get acknowledgement of acceptance. This notice of occupation, okay, in addition to this certificate of stability, you need to send a notice of occupation in the prescribed form to the Chief Inspector at least 15 days before occupying and using any premises as a factory. And then you need to apply in the prescribed form to the Chief Inspector for obtaining registration of the factory and an application in the prescribed form for obtaining a license by paying the requisite fees in the local treasury. So you need to obtain registration and then you need to obtain a license. You need to obtain prior approval of the local authority prior to connecting the factory's drainage with public sewerage system. If you do not want to connect the drainage system of the factory to the public sewerage system, then you need to obtain approval in respect of the arrangements made for the disposal of trade waste and effluents from the health officer. This is with respect to the Factories Act. We go on to the next legislation, which is the Indian Boilers Act. Under this act, once the boiler has been erected after inspection, you need to apply to the Inspector of Boilers for registration of the boiler in the prescribed form. This has to be accompanied by the prescribed fees. You have a compliance under the Water Prevention and Control of Pollution Act. You need to submit the prescribed form along with the applicable fees for the purpose of obtaining consent to operate. So, in addition to the first approval that you sought before you started the construction of the factory, you now need to obtain consent to operate from the Water Prevention and Control of Pollution Board specified under the Act. Similarly, you need to take consent from the board that has been specified under the Air Prevention and Control of Pollution Act, which is typically the State Pollution Control Board. You need to ensure that you are registered under the Professional Tax Act and the rules. You need to ensure that a certificate of enrollment is obtained from the authority specified under the Professional Tax Act and rules, under whose jurisdiction the principal office is situated, and for all units within the state where the factory is situated. So, you need to ensure that if your factory has more than one unit, you need to ensure that you get your professional tax enrollment in respect of, you need to ensure that you get your professional tax enrollment in respect of all the units within the state where the factory is situated. You need to obtain permission under the Lifts and Escalators Act, which is prevalent in the state in which we are setting up a factory. And you need to apply within the time period specified after the completion of such installation and erection for a license to operate the lift or escalator, and this application needs to be made to the Chief Inspector under the enactment. We need to ensure that you are in compliance with the provisions of the Explosives Act 1884 and with the Gas Cylinder Rules 2004. You need to apply in Form C to the Chief Controller or Controller for license to store, process compressed gas in cylinders. You need to accompany the application with the requisite license fees and then pay the fees in the manner that is specified to the Chief Controller of Explosives or the authority that may be specified. You need to be in compliance with the provisions of the Petroleum Act 1934 and the Petroleum Rules. You need to obtain signed certificate of safety from the competent person and furnish it to the licensing authority before any petroleum is stored for the first time. You You also need to obtain the certificate from a competent person certified that the electrical apparatus installed in the hazardous area have the safety characteristics for which they have been approved. So we've already seen the required compliance that you need to do before setting up any of these containers which store petroleum. And if you look at the enactment, it also specifies a certain area as an hazardous area, the area in which these containers are kept. A certain perimeter around these containers is called the hazardous area and is certified as an hazardous area under the Act. So we need to ensure that all the electrical apparatus that is also kept along with this storage equipment have the safety characteristics, and they have also been approved. You will have to ensure that you are in compliance with the Explosives Act, read with the Static and Mobile Pressure Vessels Unfired Rules 1981. This compliance is to be carried out after licenses obtained for storing compressed gas in pressure vessels. So after you obtain the license that has been mentioned under the Petroleum Act, then upon receiving license for storing compressed gas in pressure vessels, you need to ensure that the number of you need to ensure that the license is prominently marked and displayed in your premises. The number of the license which you obtained has to be mentioned. The emergency telephone number of the local fire services, police and principal marketing company has all to be mentioned and displayed in your license premises. There are certain compliances under the Bureau of Indian Standards Act, read with the Bureau of Indian Standards Certification Regulations and the Bureau of Indian Standard Rules. This compliance applies if standard marks as defined below is used in any product. What is a standard mark? A standard mark means the Bureau of Indian Standard Certification mark specified by the Bureau to get a particular Indian standard, and specifies and also includes any Indian Standard Institute certification mark specified by the Indian Standards Institution. So what you need to do to be able to obtain these standard marks is stated in the following part of the slide. If you have any clarifications on this, we can take it up later. You have another compliance also under the same enactment and rules. In case you want to apply for grant of license for management systems certification to the Bureau, you need to do it in Form 4. You need to get your application form signed by the concerned authority in your factory, and need to follow certain other processes like sending a supplementary questionnaire that has been that is required to be duly filled up, and the process for that is mentioned in this slide. If you have any questions, we can take it up later. This is basically for your ISO certifications. If you have any systems and processes in place for which you have for which you need certifications, ISO certifications, this takes care of that requirement. The plastic waste management and handling rules. You need to apply for registration prior to manufacturing plastic carry bags, multi-layered plastic pouch or sachets in case you are manufacturing such items. Now we come to post-production. What happens post-production of your goods in the factory that you set up? You have a compliance under the IDRA, with the registration of licensing of industrial undertaking rules. You need to file Form IEM, the Industrial Entrepreneurs Memorandum, intimating status of project prior to commencement of production. file IM Form 1 Part B after commencement of production. So filing of Form IM the filing of Form IM was taken care of when you set up your factory. Now you need to file Form IM Form 1 Part B after commencement of production. Under the Factories Act, this compliance is applicable if a factory carries on any hazardous process. So unless your factory carries on any hazardous process, there is no compliance under the Factories Act. But if it does, then you need to obtain a certificate of fitness in the prescribed form for carrying on hazardous process from the factory medical officer. You have certain compliances under the Legal Metrology Act. So under this act, this is something that we dwelt in the previous session. If some of you were there, you would understand where I'm coming from. So, so the Legal Metrology Act has certain compliances with respect to how you have to package and display the items that you intend distributing and selling in the market. So in case you're selling packaged items like biscuits which are packaged, or any other processed food items which are packaged, or even electrical goods which are packaged like TVs, televisions, music sets, etc. You need to ensure that you are in compliance with the Legal Metrology Act, and prior to importing and prior to selling and prior to distribution, you need to ensure that you're in compliance with the provisions of the Legal Metrology Act with respect to package and display of the with respect to package, the weights in which you're packaging the commodity, and with respect to the display of the package, the norms that you need to follow while displaying something on the package. All those compliances are mentioned under the Legal Metrology Act. So this is something you need to take care of post-production. In addition to the various laws that we've just covered, albeit very briefly, there are certain other legislations that you need to ensure you're in compliance with when you are carrying on the operations under the factory. So some of these compliances mentioned, some of these laws which you need to adhere to are mentioned here. For HR personnel, HR personnel will need to ensure that they are in compliance with the Maternity Benefit Act, the Apprentices Act, the Employees Compensation Act, the Employee Exchange Compulsory Notification of Vacancies Act, the Industrial Employment Standing Orders Act, the Equal Remuneration Act, the Industrial Disputes Act, the Labour Welfare Fund Act, the Representation of Peoples Act, the National and Festival Holidays Act, Minimum Wages Act, Payment of Wages Act, Payment of Bonus Act, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. So each of these acts are very important, to say the least, and require strict adherence to if you need to ensure that you're not slapped with any kind of a penalty which could result in fine or imprisonment later. Each of these acts have very stringent penalties associated with non-compliance, and you will need to ensure that you're in compliance with these legislations. We'll be happy to help you with any query that you might have with respect to any of these enactments and the compliances thereof. Under the Environmental Protection Act, we have the Environment Protection Act, Noise Pollution Regulation and Control Rules 2000. Under operations, you have the Food Safety and Standards 2006. You need to ensure you're in compliance with the Food Safety and Standards 2006 in case you're running a cafeteria, you're running a kitchen in your cafeteria, or you have an industry, which is in the business of manufacturing processed goods, processed food goods. So there are a lot of compliance aspects to this particular law which you need to take care of. There are some fiscal compliances you need to take care of, like central excise registration, sales tax registration, value-added tax registration, or VAT registration. So if you're a manufacturing industry, you will need to take care of excise registration, and of course sales tax and VAT will follow. You will also need to take care of the various compliances in terms of maintenance of registers. You will have to take care of various compliances like the periodic filings you will have to do under the enactment, because all this will also include stringent penalties for non-compliance. If you are starting your factory in an industrial estate, you need to ensure that you apply. You need to ensure that you have sanctioned a particular plot or shed in the industrial estate, so that you need to follow certain compliances. You need to ensure that you have the requisite ability to be able to follow those compliances in terms of your financial capital, your financial wherewithal, and prior experience. Application for allotment of government land or agricultural land. Similarly, you will have to apply with proof of your ability to be able to fund the project and be able to run the project. Power and water requirement. You need to again apply to the distribution company for ensuring that you have power supply and water supply before you start the factory. Well, the latter two parts, that is land for project and power and water requirement, don't have any legal compliances attached with it. It's more of facilitatory information that we're providing here to be able to tell you that there are certain other requirements that you need to do if you are starting a factory. Well, that's about it. So I think I'm done with my side on the lengthy monologue that I just did, and I'll be happy to invite questions.